There's a case involving congressional redistricting in Virginia where the plaintiffs had argued that it was a racial gerrymander under the Shaw v. Reno line of cases. Redistricting cases are different than every other case because it's a direct appeal to the Supreme Court, meaning you don't have to get cert granted, you get an automatic appeal. We had lost 2-1 in the district court, and our argument in this case was that it wasn't a racial gerrymander, that the black majority district had been treated just like all of the majority white districts, and that they had preserved the core of the existing district, and to the extent they made changes, it was to protect the incumbents in the surrounding districts. So the Supreme Court's made it clear that if you would have done it for political reasons as opposed to racial reasons, then it doesn't constitute a racial gerrymander. And we felt that the plaintiffs had clearly not made the case that it was race rather than politics. Indeed, they conceded that even if every resident of District 3, the district at issue, had been white, we would have done exactly the same thing. Well, like a lot of my arguments, it was a very hot bench in the sense that the justices were very active in their questioning. It looks like it's going to be a closely divided decision, as some of these cases are. And there was the additional wrinkle of whether or not we had standing to press the appeal, because the state had not taken appeal. So my clients, who were the 8 congressional Republicans from Virginia, there was a question as to whether or not they had standing. So it was a mix of very pointed questions about whether we had standing, and on the merits, whether or not we had made our case.
The question presented was whether the federal racketeering statute, RICO, applies to events outside the United States. Our case involved allegations of bad conduct in Europe and Central and South America. It involved allegations of a RICO enterprise that consisted of bad actors entirely in Europe, and it involved allegations of injury that happened exclusively in Europe. Federal law has a strong presumption against applying statutes extraterritorially. Supreme Court a few years ago decided a case called Morrison, in which they strengthened that presumption and held that the securities laws don't apply extraterritorially. After Morrison, every court to have considered the issue held that RICO has no extraterritorial application at all, and yet the Court of Appeals in this case, the same court that was reversed in Morrison, applied RICO to a case involving foreign conduct, a foreign enterprise, and foreign injuries. First and most important, that nothing in RICO itself gives any clear indication of extraterritoriality, and we therefore said that a violation of RICO can exist only if there's a domestic enterprise, and that a plaintiff seeking recovery on a RICO claim has to allege and prove a domestic injury.
Our client, Walter Himmelreich, is an incarcerated federal inmate, and he was serving a sentence in a prison in Ohio where he was assaulted by a fellow inmate. That fellow inmate had earlier threatened to attack Mr. Himmelreich. There is evidence that prison officials knew about these threats, and they nevertheless moved the fellow inmate from segregated confinement back into the general prison population, where he immediately and violently assaulted Mr. Himmelreich. So Mr. Himmelreich sued the United States for negligence and also sued the prison officials in their personal capacities for violating his Eighth Amendment right against cruel and unusual punishment. So the trial court in Mr. Himmelreich's case dismissed his Federal Tort Claims Act action as falling within one of the FTCA exceptions to liability. Legally, it's about the intersection between the Federal Tort Claims Act and the Bivens remedy. The Federal Tort Claims Act is a statute in which the government has accepted respondeat superior tort liability for the torts committed by its employees, and it provides a plaintiff with a remedy against the United States itself. The Bivens remedy is a court-created remedy that allows a plaintiff injured by a federal officer to sue that federal officer in his personal capacity. There's a provision in the Federal Tort Claims Act that's known as the judgment bar. That provision says that if a plaintiff has obtained a judgment in a case against the United States under the Federal Tort Claims Act, that judgment will bar or preclude a subsequent lawsuit against the employee in his personal capacity. There are several categories of torts that are excluded completely from the government's acceptance of respondeat superior liability. And the legal question is that if a case is dismissed because it falls within one of those exceptions, is the judgment bar triggered, and does the judgment bar then preclude a suit against the federal officer in his personal capacity?
We represent a very diverse group of Catholic organizations that provide charitable services throughout the country. They include Catholic high schools and elementary schools that serve primarily inner-city populations, Catholic Charities, which serves a wide variety of inner-city and not inner-city populations that tend to be the poorer amongst our population, as well as the dioceses and archdioceses of which they're a part. There are two basic laws at issue. One of them is called the Religious Freedom Restoration Act, and it's a federal statute that protects the right to religious liberty of both individuals and entities. The other, which is what we're challenging, is called the contraceptive mandate. And what the mandate really does is it requires these religious organizations to include as part of their employee health plans various products and services that they oppose on religious grounds. And so the question is, can the government force these organizations in their health plans to cover these products and services that go against their sincerely held religious beliefs? The reason why the outcome of the case is so important is because it goes to whether these organizations can engage in the world consistent with their religious beliefs. Under this law that we're challenging, they really have to decide between the two. Are they going to engage in the world, or are they going to maintain their religious identity? Because what the law requires that they do is to surrender their religious identity if they want to engage in the world. For our clients, those two things are not separable. They engage in the world because of their religious identity, and we believe that a law that forces them to choose between those two things is fundamentally unjust.